So in case you're in the wrong place, you are at Eviction Ban Ends, What to Expect, which is co-hosted by 4 in 10 and our wonderful member, Advice for Renters. Just in terms of this evening's session and how it's going to work, you may notice that it is being recorded. However, you will not feature in the recording. You will be edited out of the recording. So whether you are showing your camera right now or not, you will not feature in this recording. This is just to allow clips and the full video to be accessed for individuals that can't make it this evening. One of the questions you may already have is, will you receive this recording or the slides after the session? The answer is yes. Following today and this evening, you will receive access to the resources that Pat and I refer to throughout, and also the slides. We do ask that whilst Pat and I deliver the majority of today's session, that you do remain on mute. This just helps avoid background noise, which may be distracting for others. There is also a short survey, which we have at the end, which would be great if you could complete. It just helps us understand things that you found useful from today's session and things that perhaps you did not, and where 4 in 10 and Advice for Renters can improve on that. But without further ado, what is it that we're going to be covering this afternoon? Well, firstly, we're going to be talking what exactly was the eviction ban? When was it? Why has it ended? And what might that mean for your organisation? Then I'm going to hand you over to Pat, who's going to be talking about the experience so far since the eviction ban came to an end. And we're going to be talking a little bit about tenancy arrangements and types of evictions that can take place. Some of you may have experienced some of those evictions already amongst individuals you're working with, and others may be new to that. And we're going to talk a little bit about some examples and some practical knowledge that you can take forward. And then we're going to end by identifying those at risk of homelessness and the way in which the law interprets homelessness here in the UK. And lastly, we're going to be joined by a solicitor from Advice for Renters for some questions and discussion. So if you have any questions with regards to the case you're working with, or just questions in terms of the stuff that Pat and I have covered, please hold that until the remaining 10-15 minutes. But if you do have questions as you go, please put it in the chat bar, which I'm going to, which is on the right-hand side of your screen, and I'm going to put a test message in so you can see that now. But if you do have questions as you go, please do put them in there. Last thing before we get going into the content is we do also have a session tomorrow, and that is on more rights and entitlements. So that's financial entitlements, that's rights with regards to your tenancy and so on. So if that's of interest, do let us know and we can sign you up for tomorrow's session too. Okay, so what exactly was the eviction ban? Well, the eviction ban was a piece of legislation that was in place from the beginning of the coronavirus back in March 2020 and recently came to an end at the end of May, so May 31st. This was a significant piece of legislation because it provided the main form of protection for renters since the pandemic began. But what did it actually do? Well, you may have noticed that in your communities, a lot of individuals might have been struggling with rent, but they may not have been getting evicted. The eviction bans prevented processes of evictions from beginning. At times, it prevented entry for bailiffs into households, but it also stopped court hearings. So the eviction proceedings couldn't really begin. One of the key parts of this was there was a 6-month notice period. So as I mentioned, you may have found that you were working with individuals who were struggling with their rental costs, but they weren't being evicted. This is because, as I said, there's a 6 months notice period, which is required for most evictions. So all in all, this was a really, really important piece of legislation protecting the people that we're working with. What's changed and why is the removal of this going to cause quite a significant impact to your work and for renters across London? Well, now it's been removed, enforcement of warrants for evictions can begin. What does this mean? This means if someone's filed for eviction, that can be warranted and then delivered, meaning people will be evicted out of their homes. The second part of this means that bailiffs are legally allowed to enter into tenants' property. Now, there are some technicalities. So, for example, if someone you're working with has COVID, they can't enter in that particular instance. But generally speaking, bailiffs are now allowed to enter tenants' properties. The other part of this, in terms of what's changed, is the notice period. So instead of it being 6 months in which the individual had notice to leave, that is reduced to 4 months. So if someone you're working with receives a notice for eviction, now they have only 4 months notice required by their landlord or housing association or council. Just to get, there are a couple of exceptions to that 4 months, which you may come across, but generally speaking, it is 4 months. I'm just going to cover a couple of them quickly before we move on. The first is in which, if you're working with someone that unfortunately has surpassed over 4 months in rental arrears, which I'm aware that individuals that you maybe work with have surpassed that, then the 4 month notice period does not apply. It in fact can be reduced to as little as 4 weeks. Another exception to that 4 month notice period, and we are going to talk a little bit about it later as well with Pat, is antisocial behaviour, particularly if there's been a crime or the landlord can prove that there has been some illegal activity, then there is actually no notice and they're exempt from that 4 month period. There are some other extreme circumstances, such as if the original tenants died or someone provided a false statement when someone applied for a tenancy, and we're going to cover onto them later. But the key message here is the vast majority of people you are working with will be entitled to that 4 months notice. Although the eviction ban has come to the end, 4 months still gives a bit of time for you to explore some other avenues that we're going to be talking about, not just today, but also tomorrow, in terms of keeping someone you're working with in their home. But let's have a think about, how could this impact your work or the people or your organization's day-to-day activities and work. There's a number of different ways you could think about this. But what is likely is it's very likely that you're going to get more day-to-day questions about housing in the months to come. You may see an increase in anxiety or money worries for community members because of increased rental arrears and increased threat of eviction, which previously didn't happen. As a result, and indirectly, you might see an increase in other elements of your service. So for example, if you provide food parcels and you provide advice support or family support for individuals in your community, because of the threat of eviction and increasing rental arrears, you might see an increase for other elements of your service, which might not seem related to housing. Unfortunately, you may also see an invisible increase further down the line in this year in homelessness and rough sleep in your community. Another key point you may see is that you might also see funders, if you are a charity in the court today, possibly favouring organisations giving housing support, or at least supporting housing in one element or way, shape or form as evictions increase throughout the year. Now, before I hand you over to Pat, I want to get you all thinking just about sort of the scale of the problem that we might be looking at here in London. I've talked to you about what the eviction ban did and in terms of protecting renters in London and what's changed. But now I'd like you to think about, just how many people do you think might be facing this issue? So I'm going to put a poll on your screen. And it was just a question. So according to an LSE study, how many renters in London are anticipated to be in significant rent arrears by the end of 2021? And you should see that question on your screen right now. It is anonymous, so neither Pat nor I can see who's voted what. It's just to get you thinking about, we've talked about what the problem is, but just how many people do we think might be expected to be experiencing it? Just going to wait for a couple more of you to answer. We've had about 2/3 of you answer so far. Okay, I'm sorry if you're that last person still thinking about that, but for time reasons, I'm going to move on. So 3 of you got the correct answer. It is in fact 400,000 renters here in London that are anticipated to be in significant rent arrears and therefore threatened by eviction. That is why the eviction ban was such an important piece of legislation, and that's why hopefully the information that Pat is going to cover and what I'm going to cover in the latter part can be of use to you and your organisation moving forward. And if you're interested in just about why that is, then we've got the link for that there. What does this mean just before I hand over to Pat? Well, it's been 1 month since the eviction ban came to the end on the 31st of May. Now, because there is so many people in rent arrears right now, there hasn't really been a huge increase in rent arrears just yet, but do expect there to be a backlog of rent arrears and a steady increase in months to come. There's also a chance that when the furlough scheme eventually comes to an end, and if the £20 universal credit uplift is scrapped, which is due to happen on the 30th of September, that we see the scale of that issue really taking place. I'm going to hand you over to Pat, who's going to talk to you a little bit about advice for renters, what they do, and also about some key eviction information.
Great, thanks ever so much, Keir. So my name's Pat Fernandez and I work for Advice for Renters. We are a charity that campaigns and advocates on behalf predominantly of private rented tenants under the legal aid scheme. We represent at court, at tribunals, and as I say, we campaign in a collaboration with various other organisations as well for the protection of private renters specifically. So we take a very holistic approach in the way that we treat clients, and which is where I come in, and my role is as the financial inclusion manager. So in addition to all of our legal services, we also offer a debt management centre, crisis micro grants via our partners Acts 435. We facilitate Rent Mutual, which is part of Hillingdon Credit Union, to encourage people to save and offer affordable and equitable credit whenever they find it necessary. We have a welfare benefits expert. We, on the soft side of things, we do one-to-one community money mentoring, financial capability workshops. We offer energy advice, and probably most importantly for you guys, we also support other organisations to increase their financial capability offering as well. So do feel free to talk to me about that. So I'm going to put up a disclaimer right at this particular point. As I say, I'm a financial inclusion manager. Now, housing law is incredibly complex and probably far deeper than any of you will ever need to understand and know, but it will, as Keir's described, have an impact on the sort of services that we deliver and the sort of needs that we see our clients having as well. So I'm going to try and present this to you in very small, bite-sized, manageable pieces that we as frontline advisors with other specialities would need to have an awareness of. So as Keir says, we've got my colleague Elizabeth Salmon, who's one of our duty solicitors, joining us for the last 15 minutes. So if you have any mega technical questions, whether about your clients or whether that are indeed about yourselves, then I'll ask you to save those to then. So the eviction ban so far, well, I guess when this all started, probably in August before it was extended, we were expecting to see a tsunami of cases with landlords desperate to evict all these people that haven't been paying their rent. So it was extended, the notice period was extended to 6 months. At that period, that ran until May the 31st of this year. Landlords will have to give 2 weeks notice. So it's probably fair to say that it's only about now that we're beginning to see the impact of the reduction of that notice period. However, that said, we haven't seen a significant increase in cases. The caseload is pretty much the same at the moment. But again, as Keir mentioned, there is a tremendous backlog going on, so things will start creeping up. Keir mentioned the 30th of September. Another significant reason for that date, in addition to the end of furlough, is also the fact that we're expecting that the notice that needs to be given to tenants for eviction to decrease again back to its normal 2-week period and 2-month period for the different types of eviction. So that date may actually prove very, very significant. So yeah, if you want to move on to the next slide, please. Okay, so I'm going to try and break down some of these terms for you, so that you can have a sort of awareness of them and understanding of them. So there's two basic types of tenancy arrangement, the fixed term and the periodic. Okay, and if you imagine these a little bit like a mobile phone contract, it's the best way for me to get my head around it. So the fixed term will, as the name suggests, runs for a fixed period. It might be a fixed term of 6 months or 12 months. And once that expires, then the tenants will move on to a periodic contract or term, if you like. And that runs on a week by week, monthly basis. So it's a bit like having a standard contract mobile phone and having a pay-as-you-go mobile phone. After a fixed term, all tenancy arrangements will resort to being a periodic, but they little difference in how they actually affect your rights. So that's the actual various types of tenancy agreements. So next slide there, please, Keir. Oh, one thing I forgot to mention is that if somebody has a 12-month fixed term, the landlord may actually insert a break clause in there at 6 months. So what this means is that the landlord could either seek to terminate the contract, or the tenants can seek to terminate the contract at that 6-month period as well. So that's a break clause. So there's different types of tenancy arrangements, and probably the best way to think of these are in terms of who might actually have that particular arrangement. So most private renters will have an assured short hold tenancy, bit of a mouthful there. So this is typically what a private renter will have, and a landlord can issue a Section 21 no fault eviction notice. And I'll talk a little bit about those a little bit further on. So you'll find that most council tenants will have a secure tenancy. However, if a client has been placed in temporary accommodation, they may not have a secure tenancy. It may be under the terms of being an assured tenant or an assured short hold tenancy. So in a housing association, you'll find that most tenants will have an assured tenancy. So Section 21 can't be issued for an assured tenancy. So this is where you may get a slight sort of deviation here. So if a council tenant is placed in a housing association and under temporary accommodation, they would actually have an assured tenancy as opposed to a secure tenancy, while they remain in temporary accommodation. And then the fourth type of tenancy is an introductory tenancy. And this is one that's given to first-time council renters. It's almost like a trial or probationary type tenancy before they move on to the secure tenancy. So already lots of terms and jargon there already. So next slide there, please. So there's certain types of tenants who aren't actually classified as tenants in the eyes of the law, if you like. So some student accommodation, people that might be provided with accommodation as part of their employment. So something like a live-in nanny, or people that are fortunate enough to have staff in the garden annex, that sort of thing. Also lodgers. So if you are lodging in the landlord's premises, they live in the same building, then they are excluded as well. Holiday, hotel stayers, people in emergency accommodation, as we mentioned earlier, all of these are not considered as being tenants under the law, and don't have tenants' rights. Thank you, Keir. Okay, so now to the crux of it, the different types of eviction notices. So we have a Section 8, which is an at-fault eviction notice, and a Section 21, which is a no-fault eviction notice. So these are the two ways that tenants can be evicted, private tenants can be evicted in short hold tenancies. So Section 8, so they're used when a landlord believes there's been a breach of the contract, but not exclusively. So there may be situations in which it may be discretionary rather than mandatory. So for example, if a tenant dies, or if the landlord had written into the tenancy contract that he used to live at the property and may seek to live at it again. But typically it is for breach of contract, and rent arrears would come into that under grounds 8, 10 and 11. So the Section 8 notice should explain what grounds for possession your landlord is using to try to evict you, and why your landlord is using these grounds for possession. For example, if you have rent arrears, or if you've damaged the property, antisocial behaviour, illegal activities, as we mentioned earlier as well. So that is a Section 8 eviction, typically used for excessive rent arrears. So the Section 21 notice. So this is where a landlord isn't required to show any fault or breach of tenancy terms on the part of the tenant. So this is typically what we call a no fault eviction notice. A landlord can just decide that one day he'll wake up and decide he doesn't want you in the property, providing he follows all of the necessary procedures with the correct time periods, notice periods, he can just evict you, I'm sad to say. So after a fixed term tenancy ends, if there's this can be served after a fixed term tenancy ends if there's a written contract, or during a tenancy with no fixed end date, and that's known as the periodic tenancy. So basically, if a tenant is moving into a property, a landlord cannot evict them within the first 6 months. A landlord cannot serve notice within 4 months. So theoretically, you're protected for the first 6 months of being in that property. After 4 months, the landlord can serve you notice, give you, as it stands at the moment, 4 months notice that he wants to take you to court to seek possession. As of September, I don't want to confuse you, we think this, or sorry, October, we imagine that this is going to go back down to 2 months notice again. So typically somebody could be in accommodation for 4 months and be given notice on the day after that 4th month that they will be seeking possession on the day after they have been there for that 6-month term. So a little bit complicated there. Hope you got the gist of that. Okay, so next slide, please, Claire. Okay, so there are some very complex procedures surrounding the proceedings for Section 21. And typically landlords get them wrong. So this is where Advice for Renters and the likes of our organisations sort of rally to the rescue of the private tenants. So the law's complex, and as I say, they often get it wrong. So most Section 21 notices will be given on the form that you see just to the left there, a 6A. Now there's also a little bit strange is that you may get some estate agents or management companies who will copy this form onto a Word document, and that is acceptable as long as the text is absolutely identical to that. So that may throw you if you see a document that doesn't look like it does on the left-hand side there. So the notice won't be valid, as it says, if it's not on the correct form or an identical one. And there are some exceptions for older tenancies, which predating 2015 that have not yet been renewed. So the next slide. There we go. So what your landlord can't do. So for an assured short hold tenant, your landlord can't evict you during the fixed term of the tenancy by using the Section 21. So that, again, as I say, would typically be within the first 6 months, or if it's a 12-month fixed term contract, there may be a break clause. There is typically a break clause in there. So it's a get out of jail card for for both the landlord and the tenant, should they want to leave early as well. So your landlord can't give you a Section 21 notice during the first 4 months of your tenancy. And if you remember, I said they can give it to you the day after that, that first 4 months, so that it expires after the term. So your landlord will need to give you notice in the correct way, and he may need to prove this as well. So we're going to talk a little bit about that tomorrow, because that quite often provides a defence for our lawyers if the terms of their contract stipulated, the terms of the tenant's contract stipulated that any notice given would have to be in writing by recorded delivery and the landlord just sent them an email. That may give us some negotiation room as a defence and buying time, in fact. Okay, next slide, please. So we just wanted to think about a few scenarios where the sort of thing that you might actually encounter in real life with your clients and the sort of questions that they might have. So what do we got here? I paid a deposit. Does this matter? Well, a Section 21 notice will be invalid if your landlord didn't protect your deposit in a government authorised scheme. So this is really important that once you've paid your deposit to your landlord, that they actually protect it underneath one of these schemes. It stops landlords from skipping off to Barbados on the proceeds of your deposit, which you may never see again. So it's for your protection. It may also be invalid if your deposit was protected late. So after 38 days, they need to do it within 38 days, basically, and you weren't given all the necessary information about its protection. Okay, so that's really, really important. What you may find, however, as we say, Section 21 notice can't be issued under these circumstances, but what you may find is that sneaky landlords will go, oh, you know, thank you very much, here's your deposit back, and then they'll serve you a Section 21. So that's their way of getting around that sort of particular anomaly. Okay, so next slide, please, Kim. Okay, does the property need a license? So Section 21 will be invalid if your landlord doesn't comply with the necessary property licenses. And we've got, as I say, these slides will be coming out to you. So all of these links that you see underlined in blue are live, so you can check that the property has the correct license. So there are various licenses for various types of properties, also for various areas, and for things like HMOs, houses of multiple occupancy may require additional licenses also. So next slide. So eviction notices. At the start of a tenancy, the landlord must give you a copy of the EPC, or the energy performance certificate. So that is the certificate that you normally see typically on front of any white goods appliances, telling you how much energy it's using, how energy efficient it is. Landlords are no longer allowed to rent properties that are rated F or G. So if it's rated A or B, it means it's incredibly energy efficient. If it's rated F or G, right down at the bottom there, it means that these properties are incredibly, well, they're difficult to heat. It's going to cost you a lot more money to heat a property. You're basically burning your money. So I think Kira's just going to show us around where you can find an EPC certificate and what it looks like.
Yeah, so as Pat mentioned, it's an incredibly, it can be a really important thing. You may be sitting there sort of hearing the words EPC or energy performance certificate and might go over your head in terms of significance. But as Pat mentioned, it's completely illegal to rent a property without one. But what's more is it's incredibly easy to check, and it also prevents you from being evicted from your property if your landlord does not have one. And just to give you an example of how easy it is to check. So this is my postcode. You just put it in here, and I want to give you an example of a property that is on my street that is privately rented and does not have an EPC, which is invalid. So this is a privately rented property, as many in my local area are privately rented. We can see from going on this website and just clicking in here that this energy performance certificate is invalid. So the landlord is illegally renting this property. It's also, the energy rating is incredibly low. Pat, a bit is the minimum it can be, right?
E's the minimum it can be.
Yeah,
so anything lower, F or G, they can't rent.
Yeah. Anything below an E rating, it is illegal to rent. But more importantly, is this it's completely expired, and there are tenants renting this property illegally, as their landlord has not issued an EPC. The scenario which may occur is someone in this property just on this road maybe served a Section 21, so a no fault eviction. And if the landlord does not have an EPC, they cannot be evicted using a Section 21. So it may seem like an insignificant part of the eviction puzzle, but it can actually provide a form of protection for your renters that you're working with.
Yeah, that's also a sneaky defence that we use as well. So we would encourage you to encourage all of your tenants to check that they do have an EPC certificate. If they find that their EPC certificate is anywhere between A and E, that's great. They've got peace of mind. They're quite at liberty to stay in that property and rent it. However, should the landlord try to serve proceedings having not given them that EPC, again, that will be invalid. So we don't recommend, once you've got sort of verification that your EPC is acceptable between A and E, then we just suggest that you keep that under your hat, because it may well prove useful when it actually comes, or should it actually come to eviction, from being able to buy time and causing the landlord to have to reserve all the notices with the appropriate documents again. So that's the EPC. What's also critical is receiving a gas safety certificate, obviously where the building has a gas supply. I'm just on electric, and a current copy of the government's How to Rent guide, or Guide to Renting, I should say. So you can check the current versions in there when you go live. Now, these three are the ones that we've highlighted in particular, because these will negate the landlord's ability to use a Section 21. There are also additional requirements, such as the electrical safety report, smoke and carbon monoxide alarms, fire safety. So again, as we say, in the case of non-compliance with any of these things, the council can take an enforcement action and fine the landlord. So, you know, making sure that you've received all of this documentation is really, really key, really important. So next slide there, please, Claire. So I think my landlord's given me notice because I complained about disrepair. Okay, so your landlord cannot issue a Section 21 no-fault eviction notice if you complain about the condition of the property. So what you can do and what you should do in this circumstances is report it to the council. So the council can issue a ban for 6 months where the landlord has been given a specific form of notice. They can issue this as an improvement notice by the local authority. Okay, so it's legal for a landlord to evict you on the basis of disrepair if you've complained. Okay, and the next slide, I think we're back to you, Keir. Yeah.
Yes, and I can just for Anna from Z2K and Roz, we're going to answer those questions come the end. So we're just getting to the end of the session. So 10 more minutes, and then we'll address those directly. What Pat spent some time diligently talking about are some really useful defences and useful things for you to be aware of in order providing an extra layer of protection for individuals you're working with now that the eviction ban has come to an end. One of the things that you're probably already doing, or may be doing as a result of an increase in evictions and increasing rental arrears, is emotionally supporting those at risk of eviction. Now, many of you probably already support individuals day to day with a variety of other needs, but there are some additional things in terms of emotionally supporting people at risk of eviction that could be useful. Some of the key ones being reminding them they may not have to leave their property. For example, Pat has just talked about a number of different ways in which Section 21s would be invalid. So remind them they may not have to leave their property. If they receive a text from their landlord tomorrow saying that they have to leave by Tuesday, one of the best things you can do is, confidently reassure them that they're not having to leave their property next Tuesday. Some of the other stuff includes signposting to mental health professionals, for example, if they are suffering, or other organisations in your community. We're going to come to the end of the session today. One of the brilliant tools that 4in10 have just launched, which you can find a number of different services in London for a variety of different needs, which could help individuals. We're going to come to that at the end of the day. But we've talked about the threat of eviction. One of the outcomes of eviction can be homelessness. But here in the UK, it has a particular definition. So when you're working with individuals, it can be useful for you to understand, is the council or is this person legally understood to be homeless? So our definition is that when a person has no legal right to live in accommodation anywhere in the world, and threatened homeless, which involves is linked to eviction, which we just talked about, is when someone is threatened to become homeless as above within 8 weeks of a given point in time. So 8 weeks before they are due to be homeless. So we're going to go through a couple of ways in which individuals are interpreted as homeless here in the UK. Okay, in order to gain assistance from your local London council, a homeless person must meet the criteria on this slide and the slides to follow. Firstly, that they have no legal right to a property anywhere in the world, and that will come into play within 8 weeks. And it's the other element of that is that it's unreasonable for them to remain in their accommodation. So what's understood as unreasonable are, for example, instances of domestic abuse, incidents where that house or that housing quality is a threat to health or threat to them in any way, shape or form. So anything that is of harm or it's not adequate in terms of sleeping arrangement, for example, in that instance, they would be classified as homeless and within 8 weeks of a legal right to home. In order to receive assistance as well from the council, there are a couple of other requirements. So for example, you do have to be a UK citizen or have indefinite leave to remain or some other proof of residence granted by the Secretary of State. Now, there are some further elements to add on to that. In particular, one to avoid or one to be aware of when you're working with individuals is the idea of being deliberately homeless. So I'm in inverted commas, most people you're working with are not deliberately making themselves homeless in any way, shape or form, but in the legal definition, the law may interpret them as having deliberately made themselves homeless. So what I mean by that and what the law means by that is they mustn't have left their property when it was in a fit state, or they could have reasonably stayed within that property, or they have family members in which they could feasibly stay with. They have an extra bedroom with a bed that's fit for purpose. In that case, they will not be interpreted as homeless. It would be interpreted as deliberately or intentionally homeless. On the left-hand side of your screen, you have some priority groups. So they include a pregnant woman and a partner, individuals that have dependent children, any individual who's vulnerable as a result of mental illness, age, or another lens of vulnerability, or someone who has been homeless as a result of an emergency, i.e. Could be a flood flare or so on, but there can be other instances there. The final part of this is typically you must have a local connection, not always. So there's some London Borough Councils where this is certainly not the case because of relatively less individuals being homeless or threatened homeless. But typically you need to be a resident in a local area or part of London for at least 2 years in order to receive support. However, and it's a big however, regardless of all the criteria that I've just talked about for the last 2 or 3 minutes or so, it's a great idea to get in contact with your council, even if individuals you're working with don't apply to some of the criteria. This is because although they may not have a duty to house you, they will have to come up with a personalised housing plan, which can help support an individual. And for example, even if someone it hasn't been a local resident, they may be able to signpost and to support via a different London Borough Council, which is not a million miles away. So it is really, really useful, regardless of the criteria that I've just talked you through, that you get in touch with your council, particularly within that 8-week period in which they're classified as threatened homeless as soon as possible. Mm-hmm. So the final part before we're going to go on to some questions, we're just going to go through some couple of examples, and hopefully that has helped to understand how the law interprets individuals as homelessness, as homeless or not homeless. So if you could put in the chat your answers to these questions, and we'll go through some of the answers. So Nadim comes to you requesting help with homelessness after receiving a possession notice. His landlord wants possession of his property, his or her property, in 4 months so he can sell it. Is Nadim homeless? Does anyone have any guesses or ideas?
So we've got 2 no's so
Two no.
far.
Sharon said no. Roz says no. Renata says no. Yes, within 56 days or 8 weeks. Well done. I think the vast majority of you got that right. So the answer is no, not yet. Potentially, you could be homeless when he falls within 8 weeks, but at this moment in time, Nadim would not be classified as homeless yet. But if he has nowhere to.
However, it is fair to say that if his mother decides that she doesn't want him to stay there, then she's perfectly at liberty to actually evict would be the wrong word, but to tell her son that he can't stay there. What would be useful under those circumstances is if the mother could write a letter stipulating that this is the situation so that he could present this to the council. And also, he would be considered homeless if, for example, the mother was living in a 1-bedroom bed sit and he was sleeping on the floor. That would be deemed unreasonable. So in those circumstances, he could be deemed to be homeless. Yep, back to you.
Okay, another example for you all. Karim, he tells you that he's been living in his mother's accommodation and he could no longer afford to stay, in his home as his rent increases. Is Karim homeless in this instance?
Oh, I beg your pardon, everybody. I got a bit ahead of myself there. I was talking about the wrong chap and his mother. So I've given you the answer for that. So let's see how you
Pat has kind of given the answer away, but the answer is no, unless his mother's house is an unreasonable place to live, i.e., as Pat mentioned, the one bed sit, or it's an unreasonable condition otherwise. We've got 2 more for you. Maria, she comes to you and she says she has fled her home in Hackney to Brent with her 2 children to escape her abusive partner, who she has reported to the police after he made a violent attack against her in their former home. Is Maria homeless? Yes. Says Roz. Yes, says Renata. Yes, says iPhone. Sorry, I don't know iPhone's name. Yes, says Liza. Yes, in this case, Maria would be classified as homeless, as unacceptable for her to reside in her current property. And then thank you for those activities. With just last bit before we're going to open the floor to questions. I know some of them have been coming into the chat, and I will raise them, or you can verbally ask Elizabeth and Pat. The last thing I would like to raise is about housing help in London. Of course, we have the brilliant advice for renters here with us right now, but there are a number of different ways you may be seeking housing support, as well as other support areas in London. 4 in 10 have recently launched our Giving and Getting Help tool. This is essentially a directory of all the different organisations providing a variety of different services to those combating poverty. So, for example, you can search via London Borough. You can also search by topic. So let's say, for example, because we're talking about housing homelessness, we have advice for renters here. Let's say we wanted to search in Bexley, or we wanted to look in Camden. It would show you all the different organisations that might be able to provide housing or homelessness support in your borough. So we could do another one here. We could do family support, and then let's go Barnet. And that will show you all the different organisations in your local borough providing that care and support.